Hello and welcome to our webinar, Data Storage in the Cloud. My name is Lisa Hofmann. I'm a TÜV licensed data protection officer, and today I want to talk with my guest, Alexander Sverdlov, about how you store data correctly and GDPR compliant. Alexander is the founder of Atlant Security and a cybersecurity consultant. Before, he was security consultant for Microsoft and consulted private and governmental organizations in Europe, Asia, and the Middle East. Welcome, Alexander.
Thank you. Thank you. Glad to be here.
Perfect. So if there are any questions, you can post them during the whole webinar, and at the end, we will see how much we can answer in the time we have left. So just to give everyone a quick overview of the current status of data security. In May 2016, GDPR came into force for all EU members, with a margin of 2 years, where the companies had time to implement the GDPR. In May 2018 was the official end of this implementation period. And a lot of companies were not ready yet. They took May 2018 to start implementing the GDPR. But quite recently, the EU started to apply increasingly heavy penalties, which we all saw in the news in Germany, UK, Spain. A lot of fines came, and fines can be up to 20 million euros or up to 4% of the annual revenue of the company. Not to mention the adverse effect on the company reputation. So altogether, over 450 million euro of GDPR fines have been imposed as of today. So fines for violating GDPR regulations can be really, really high, and everybody should take care to have that covered. So in today's webinar, what will we speak about? We will speak about how to delete or not to delete, the principle of storage limitation, and if the cloud is actually safe. So therefore, we have Alexander here. He will explain this in detail, and also best practices for data storage. And finally, we will speak also about what the data cannot be deleted. So there are cases where you cannot legally delete the data. What are your options? Do you anonymize the data, or do you have use pseudonymization? So to delete or not delete, this will be the question of today. And yeah, so today we will speak about the question of when and how to delete, as well as the principle of storage of limitation. So in Article 5 of the GDPR, it states that personal data shall be kept in a form which permits identification of data subjects for no longer than it's necessary for the purpose for which the personal data are processed. So if personal data collected by companies for a specific purpose fulfilled their purpose, they are no longer required, then the company must delete this data without further requirements. So the right to be forgotten contains a little bit more and more precise requirements. This is in Article 17 of the GDPR. As I said, it's called the right to be forgotten or the right to deletion. So it states the several reasons for the occurrence of an obligation to delete the data. For example, including that personal data are no longer necessary for the purpose for which they were collected or otherwise processed, that the data subject withdraws the consent, that the data subject objects to the processing of the data, or that the personal data were processed even unlawfully. I mean, this can happen. You have no legal basis for the processing, and therefore, of course, you have to delete the data. The deletion of the personal data is necessary to comply with a legal obligation under the union law or the law of the member states to which the controller is the subject. However, the obligation to delete shall not apply if the personal data are still required. There are some examples for it. For example, that you need them for the exercise of freedom or expression of the information, or if you needed to comply with a legal obligation requiring processing under union or national law, for reasons of public interest, for example, in the field of public health, or to assert or exercise or defend even legal claims. But deletion and retention obligations must be taken into account all the time. So various legal and contractual obligations therefore result in companies being obliged to retain personal data for a certain period of time. After this period of time, the aforementioned obligation to delete the data takes effect. In Article 18 of the GDPR, the right to restrict the processing applies. According to this, the data subject has the right, under certain conditions, to request the controller to restrict the processing. And in Article 35 of the GDPR, it contains also certain deletion requirements. A deletion concept must be acknowledged and implemented, all the specifications and all these obligations. So, but what does it mean for you, for a small company in business practice? You should definitely keep personal data for no longer than you need it. You should create a policy setting standard retention periods whenever possible to comply with the documentation requirements. You should also always periodically review the data you hold and erase or analyze it when you no longer need it. So this is not a one-time thing where you look at the data and say, I delete it then. No, you really have to look at it continuously. Maybe things change, maybe the legislation changed, maybe the reason for the processing changes. So you have to always be up on your toes reviewing it. And yes, as mentioned before, the individuals have the right to erasure if the data is no longer needed. So keep personal data only for the long that the retention period you are keeping it for the public interest of archiving, scientific or historical research, or statistical purposes. But other than that, you have to delete it, of course. So we were speaking right now before about the retention period. And how should companies define this retention period? I get asked this by a lot of our clients. So you should use, of course, first of all, common sense, depending the purpose of the data. So you need to be able to justify the retention period when asked by an authority. But the GDPR does not dictate how long you should keep the personal data. It is completely up to you to justify that based on your purposes for the processing. You are in the best position to judge how long you actually need the data. So, for example, you should consider your stated purposes for the processing of the personal data. You can keep it as long as you need it for the processing, of course, but other than that, you should delete it, and there's not keeping it in case, like just in case keeping the data if you might need it. This is not legal. Or if there is only a small possibility that you will use it, you should also definitely delete it. Furthermore, you should consider whether you need to keep a record of the relationship with the individual once your relationship with them ends. So if a customer cancels the contract, you still may need to not delete all the personal data when this relationship ends, because you might need to keep some information so that you can confirm that the contractual relationship existed and that it has ended also. You need to keep like the cancellation letter and so on, as well as some other details. So for example, a business may need to keep some personal data about the previous customer, just to state if the customer complains, for example. You need the data to justify your actions. Also, another point is you should consider whether you need to keep the information to defend possible further legal claims. Again, from the customer, if he complains, there can arise a legal claim. So therefore, you should not delete all the information you might need in order you have a claim and you have to go in front of the court. And the last point is you should consider any legal or regulatory requirements. Therefore, there are various legal requirements about keeping data, such as information needed for income taxes or even for audit purposes, or information on aspects of health and safety. So this you should all consider before making a data deletion concept. So now we are at the next slide. What are the best practices for compliant data collection and storage? So Alexander, could you help us out on that?
Yeah, well, the biggest misconception about data storage is that it's safer in-house, and this is particularly true for smaller companies, where the smaller company needs to feel that it has some control over the data, and oftentimes it feels that if it transfers the data to a cloud provider, even one of the biggest cloud providers such as Amazon, Google, and Microsoft, they feel that the data is safer behind the firewall in the office rather than being publicly in the cloud, because they consider the cloud as something outside of their control, where it's usually the opposite is the case. And I can take a very recent example, the very recent example with the coronavirus, for example. The coronavirus, where is the person more protected? In a military base, which has 20 years of medical research experience, or at home, right? You may feel safer at home because it's cozy and it's warm and you feel safe. But when there is something dangerous, like a hacker or a malicious government or a competitor who wants to take your data is much safer in a larger, like, military base environment, such as a cloud provider, such as Microsoft, Amazon, or Google, rather than being in your office. Because your office defenses, most likely, if you're lucky, if you're big enough, you have a security person on staff. If not, maybe you have a very good IT company taking care of your IT infrastructure. But the IT company usually has 10 employees, 20 employees, 50 employees, and they all spend 20, 50 minutes per week on per customer. And Microsoft, for example, has probably 10,000 engineers, out of which at least several thousand, 10,000 related to security and more or less directly, and at least several thousand directly pure cybersecurity experts in Microsoft. The same applies for Google, the same applies for Amazon. They have thousands of security engineers. And the defenses that those companies build, they build them globally, and they build them so that they can survive any cyber attack. And so far, Google, Microsoft, and Amazon's cloud services have not been hacked, even though there are millions and millions of hackers trying to hack them. Now, if you compare, if a million hackers tries to hack your company, you'll be done in a few minutes. Even generally, I'll show in the later slide how much time does it take, but it's very fast. A cyber attack usually is very fast and very efficient. Yeah, like on this slide, but we'll talk about it. So on this slide, if we speak about a generic hacking attack, the hacker spends like 4 weeks in preparation on average, depending on the size of the company, the size of the target. And let me break a misconception about a hacker. A hacker is not like a hooded guy in a dark room somewhere in a basement, a single guy. Sometimes it's like it's an organization. There are organizations with 1,000 employees, criminal organizations with hackers. They have 1,000 hackers employed, and they go to work in the morning. They have team meetings, they have KPI meetings, they have targets to achieve, they have managers, and they are very, very organized. When they get an order to get data from someone, they're very organized in the planning of the attack, which usually on average is 4 weeks, as you can see on this slide. Then the average attack happens with the duration of 2 weeks. If it's a large company, if it's a small company of 50 employees, the attack duration will be 1 day. And after that, the attack is usually, in the majority of the cases, successful. And after a successful attack, on average, and average means between 0 and infinity, but on average in the middle, it's around 4 months to a few years where the attack has not been detected. Like, from my experience, I can tell you that the smaller companies, they just never find out. Like, you feel that your data is safe, you feel that it's safe because it's still there. But has someone taken a copy or a part of it and sold it somewhere or taken it home? You don't know. If the hacker doesn't let you know, if someone else doesn't let you know that the attack has been successful, you have to investigate if there was an attack. But if you never investigate, you will never know. And the average recovery is between 2 months and a year. But this is purely from a technical perspective, right? Just so you could understand how likely it is to be attacked. And in the next slide, I think we have a slide with the statistics about the hacks. Yeah, as you can see here, every single brand that you have heard of, the majority of the brands that you've heard of have been hacked. And they're like the Marriott hack, for example, they have 320 million records. Everyone who has ever stayed at the Marriott hotel, their passport data, personal information, everything has been leaked. And now all of these companies, they had security personnel, they had security teams. Twitter was hacked, LinkedIn was hacked, Facebook was hacked. It's like the US Secret Service, all the Department of Personnel Management, where all the personnel with security clearance was hacked, even though it was very well protected. What about the smaller companies? So if I were you, I would not make the choice between keeping the data in-house or storing it in the cloud. Just assume, or not assume, it's a bad word, but understand that your in-house defenses are no match for a persistent attacker or persistent attacking organizations compared to the cloud. Think of it this way. You have a small hut and there is a large fortress where you can keep the data, where thousands of engineers work day and night to protect the fortress. So move the data out of your hut. If you can, move it to the cloud. Now, is the cloud really secure? Well, again, I've already discussed that the engineering in a small business, even medium business, even a business with 1,000 employees, usually has one information security officer and a couple of security engineers when there are 1,000 employees. Again, those engineers are no match compared to the engineers available in the cloud. So if you have the option to move to the cloud, and there are even you can get their professional help from Amazon, Google, or Microsoft. You can get professional help in migration. It's just like it says in the slide. It's moving to a safer neighborhood, but I would say it's moving to a fortress. So that dilemma should never be there. I mean, it is there. I understand that you feel that the cloud is not safe, but in reality, it's orders of magnitude safer.
Thank you so much for that explanation. I especially liked the comparison to the virus because it made it so much more relatable. And we have a lot of the questions of smaller companies about if to move to the cloud, and especially they are concerned about the Cloud Act. So I know the Cloud Act a bit from the legal perspective, of course. As a data protection officer, get the question a lot: what applies to the company when they use the cloud? So I know that generally speaking, the Cloud Act does not change the process or requirements for law enforcement requests, nor other countries' local laws, meaning also the GDPR. And the letter cloud, or CLOUD, stands for Clarifying Lawful Use of Overseas Data Act. So the Act does not only cover the cloud providers, but basically every company which stores data overseas. So how did the Cloud Act came together? The US enacted the Cloud Act in 2018 as a response to a case pending before the US Supreme Court relating to stored emails controlled by the US-based data provider. So the emails in that case were stored in Ireland, and the provider argued that the reach of the US border for the emails stopped at the US border. So the Cloud Act resolved that issue by amending the Federal Stored Communications Act to state that criminal warrants served on a US-based provider extend to all emails in the scope regardless of where in the world the emails were located. And also another reason for the Cloud Act was that the US complained a lot about that the already existing act, the MLAT, the Mutual Legal Assistance Treaty, was way too slow for fast-moving criminal matters such as terrorism. So the Cloud Act was passed and allowed federal law enforcement to compel US-based technology companies via a warrant subpoena to provide requested data stored on servers in the US or on foreign soil. It creates additional safeguards for cloud content even. So including recognizing the right of cloud service providers to challenge requests that conflict with other countries' laws on national interest. Seeing like the GDPR, so if the GDPR states a harder regulation, they can challenge that request in the European Union. And the Cloud Act also does not change the process or requirements for law enforcement requests for data as a part of criminal investigation. It does not give United States law enforcement unlimited or unfettered access to data. The United States law enforcement may seek content from service providers, but in only two circumstances, and these are either they get the consent of the consumer or they have a warranty issued by the state's court in accordance with the United States criminal procedures. So cloud service providers are challenging law enforcement requests if needed to protect the customers. We have heard that a lot from Amazon and other providers. As it has been common procedure before the Cloud Act, now they still do it, so of course. So this was the legal side. But what do we have to look for on the technical side? What do we need to consider when storing data in the cloud, Alexander?
Yeah, well, just one personal experience comment about the Cloud Act and what people are concerned about. When I worked in Microsoft as part of their security team a couple of years ago, I traveled the world to all kinds of customers in the Middle East, where they're specifically very touchy about giving any of their data to the US, in Asia, in Middle East, Eastern Europe. And all of those customers, when we arrived and we tried to configure their security according to Microsoft standards and offer them Microsoft cloud services, everywhere I had the same question. Okay, there is the US legislation, the US can touch our data, they can get our data, they can read our data, and this is unbased on reality. This fear is unbased on reality. Why? Because Microsoft, Google, and Amazon, they're getting requests from law enforcement for all the time, and Microsoft is actively fighting those requests with the lawyers and the legal power available to Microsoft, which is a multinational, almost $1 trillion corporation, which the legal power of this corporation sometimes is stronger than the US government. And many times those requests are being fought against, and they're being actively refused, because if even one instance happens when the data of a customer of Microsoft lands in the law enforcement of a country which is, this request was illegal or unbased on actual serious crime, then all other customers of Microsoft will immediately leave. So think about the motivation of a big cloud provider to keep the data from law enforcement until or unless the reason for it is something about terrorism, something really serious, like child molestation or something like that, which is a real crime, in which case, if there is such a crime, the US law enforcement has partnerships with all other countries, and they will get to the data through partnerships, regardless of the Cloud Act or regardless of something like that, because when there is a crime, governments cooperate. Unless it's the Iranian government, which refuses any cooperation with the international community, but unless it's a rogue government, all governments cooperate. And they cooperate for the benefit of the citizens, for the benefit of the business, for the benefit of the companies, not against it. That's from the legal side. Just to let you know that the cloud providers really fight really strongly against those requests, unless they are lawful and unless the company sees reason behind this request. Now, about how technically data is protected in the cloud, I know that there are artificial intelligence algorithms I can speak about Microsoft because I worked there, but it's the same in Google and it's the same in Amazon. There are artificial intelligence algorithms working millions of they're operating millions of times per second. When they see millions of attacks per second, they automatically block them. Encryption in the cloud, the traffic is encrypted very well. The servers are encrypted by default very well. There are customer let's say partition encryption between customers, so one customer cannot in any way read the data of another customer. It's all encrypted. So and then the cloud providers, they have very good procedures when there is a technical request for support. Their procedures are compliant with regulations in Australia, in Europe, in US, in China, in Russia, in Europe. I hope I mentioned Europe, but all the cloud providers are building their procedures to comply with regulation globally. And if you have a IT support company which manages your IT today, it's unlikely that they have the same compliance procedures for accessing client data that, for example, one of the big cloud providers has. So, for example, when a hacker calls a small IT provider, they can play that they're you, and they can easily get the data just by pretending to be you. If they try the same with Amazon, it is highly unlikely that this will succeed, because the procedures clearly state how to gain access, how to grant access, in which conditions, what kind of conditions should be applicable. So yeah, I think we've covered that from a technical perspective.
Absolutely. I wanted to mention one more thing, and that is when you encrypt the data. So of course the big providers as Amazon, they help you encrypting the data. But then when you when you encrypt it yourself, and they don't have the key to decrypt the data is basically useless, even for the governments that request it.
Yes, one case of that is in many cases, Apple has actively refused, and is still refusing to provide decryption keys for iPhones, even when it comes to terrorism, because if they do it once, they will have to do it for every other case, even for smaller cases when they need to protect the person's privacy, because there might be some really sensitive things which the person doesn't want to disclose to 1,000 government officials. So privacy is a human right according to many companies, and they protect it as a human right.
Absolutely. So with encryption, data can be totally safe on the cloud. So, but moving to the cloud alone is not sufficient. Like, what steps should companies consider to move their data securely?
Yeah, well, as you can see in this very complex diagram, this diagram was created for larger enterprises, and it's created so that people would understand how many different elements exist when you have to say, okay, I'm taking care of security. Taking care of security means that you're taking care of data security, network security, security management, application security, monitoring, and all of those bigger elements, they have dozens, sometimes hundreds of smaller sub-elements. And to take care of them, I mean, if you want to migrate to the cloud, for example, moving to the cloud means that you have to take care, if you're a smaller company, you have to take care of the smaller, of a small subset of those that you see on the screen, but you still have to take care of the foundation, the fundamentals. You have to take care of, for example, when you have a server in-house, or you have 10 servers, for example, you have a mail server, file server, some chat server, a server for collaboration. When you have those in-house and you want to move those applications to the cloud, you have to take care of the security from an architectural perspective, from a preparation perspective, to make sure that before the move, you have taken care of those elements during the migration, you're moving the data in a safe way through a secure channel, and all the people who are doing the migration, they are authenticated properly, they're managing access controls properly throughout the whole process. And then imagine you have a mail server, right? If you just copy this mail server and you place it in the cloud, it doesn't become secure automatically. It's very important to understand. Yes, it is a fortress. Yes, it is secure as an outer boundary. But if you place an insecure server in a secure cloud, the insecure server doesn't become secure. You have to take the appropriate measures to, if I'll give you an example, in Azure, there are 281 security settings, and many of them are not turned on. They are there for compliance, they are there, but to become compliant and to become secure, you have to touch them, you have to configure them properly. All of those 281 settings, they may change, they may become 300 after a month, they then become less, but on average, there are hundreds of security settings in each of the cloud providers. So yeah, the cloud is secure.
Okay,
it is more secure. Yeah, but
it's
yeah.
really complex for me, as I have more like a small and medium-sized business background. This looks and sounds for me a bit very complex. So what should I do in this case if I'm a small company? Should I like hire someone to do that?
Look at it from this perspective. Yeah, I mean, a smaller company has much less data, much less servers, much less applications to migrate if it wants to migrate. And it will have to take care of much less issues when migrating. But yes, usually the IT provider that smaller companies use are not capable to take care of security. Their business model is about efficiency, to serve as many customers as possible, not about security. It's definitely not about security. So search in your local vicinity, in your city, in your country, or maybe you can find someone globally like myself. But in general, search for a security provider who is able to, from a security architecture point of view, look for someone with an architectural understanding of security who can see your environment, see all the weak points in it, see all the vulnerable elements right now, prepare a plan for a migration and migrate to the cloud. It doesn't have to be difficult for you. Like when your car breaks down, you don't go and learn about internal combustion engines. There are people who know about internal combustion engines. They've studied it for 15, 20 years. So it doesn't have to be complex for you. Someone who has already spent the time to make the complex easy for you, but it definitely may be complex. Just make sure that you don't abandon things because they're complex. Take care of them properly.
Perfect. So great to know that then experts like you can step in. So the next point would be how to delete data and what if it cannot be deleted. So as we spoke before, there are some regulations where you cannot delete the data. In theory, it should be deleted, but you need to store it. There are two GDPR compliant alternatives, deleting or anonymizing the data. So what is the definition? Could you get here a bit more into detail?
Yeah, pseudonymization, it's about, let's say you have a table of data with 1 million records, 1 million customers. Let's say there are 100,000 customers, and each table has columns. And in the columns, you have first name, last name, email, address, how much they've spent, when the account was created. Pseudonymization means that there is a system which will make this data pseudo-anonymous, not entirely anonymous, because if there is an algorithm changing all the names to unreadable data, you will not be able to use it. Like if the earlier mentioned example, if someone calls and complains about a product that they've purchased, and you search in the database and you don't find them because the data is completely anonymized, then you will lose your customer. Your customer will become really unhappy. They may sue you. You can lose money. Pseudonymization is a way to anonymize the data where there is still a way to get it back, there's still a way to read it in case it is necessary. Encryption, as it says here, makes the data unreadable without the right password. It's using an encryption algorithm with in the best case scenarios. The encryption algorithm is like not SHA-1 is hashing, like AES 256, for example. AES 256 is a internationally recognized encryption algorithm. Now, with encryption, they're both methods are valid. Pseudonymization uses less computing cycles, uses less computing resources. With pseudonymization, however, you have to store in a similar way as in encryption. You have to store the key somewhere, the key to the pseudonymization system, because there has to be a system or an algorithm which anonymizes the data and then de-anonymizes it when needed. In both cases are useful. Which case are you going to decide to use? I would say talk with if you have an application, in-house application that you have developed with your internal programmers, talk with your programmers and decide which is more optimal for your business, and maybe involve your lawyer to see which is more optimal for compliance with GDPR. I cannot give you the answer which is better, because every case is special, every case is different. Sometimes encryption is more applicable, sometimes pseudonymization is more applicable. They're very similar. Anonymization, however, anonymization means that you cannot read this data anymore. You can just use metadata about that data. Like, you have anonymized it, but you can still run computational analysis on it. You can still see how much money has your company made out of those 1 million transactions, in which months you have higher transactions, in which months you have lower transactions. This type of analysis doesn't require personal data. So if it doesn't require, GDPR requires you, in this case, to anonymize it. If you will never need this data to be personal anymore, but you still need the data to make analysis and computations on it, anonymize it. Because if you encrypt it, unless there is decryption, if you encrypt it, you cannot analyze it. You cannot do computational analysis on it. If you do pseudonymization, maybe, but more likely, again, you will not be able to do computation and analysis on it. So anonymization is a very good tool for long-term data retention in the form that you still need it.
Okay, perfect. Thank you so much. That clarified it a lot, and good to know what option I have as a company. So let's go to the next step. Like, how do you ensure GDPR compliance with all that what we learned from today? So to protect your data and comply with the GDPR, storage is of course not the only concern. So to implement an adequate data protection concept, you also need to perform data protection compliance analysis to detect potential dangers of, for example, GDPR violations. Then you need to create a registry of processing activities to correctly answer data subject requests, but also it's of course a legal obligation if authorities, they can request it. The next step would be also to conduct a GDPR risk analysis that helps you, of course, to define measures to close the data protection gaps you detected before, and also to define the technical and organizational measures you need to put in place in order to mitigate the risk. So what does the implementation of data protection concepts often look like in reality? I've seen that in companies I worked for, that you still work with a lot of folders. You have different folders and different employees' laptops, computers. These have to be updated manually on a regular basis. Certain data must be deleted also regularly, but this is often not the case. So also a lot of companies still work with Excel lists for processing activities, for the technical organizational measures. So really using Excel checklists, which are sent in back and forth between the certain employees in different versions. Then it's very hard to find the current updated version. And of course, the email communication is also a big problem because you collect all this information from various businesses and very highly confidential information in emails, and there's always something can go wrong. So you really need to consider the risks here. It's very unsecure. You really lose the overview. I lost the overview sometimes completely with all these different folders and all these different versions. And also, it's very time consuming to work with all these different measures. So here, the alternative, what would be the alternative to this would be a software for privacy compliance, with which you can guarantee GDPR compliance, as you can provide all the required documentation like on the spot and keep the total control of your company managing in a visual and intuitive way. And if you still don't feel comfortable using our legal assistant intelligence solution, we also offer as Pridatech DPO services, meaning we work together with you on the platform and create important information together with you. So this would be everything you need for a successful privacy program. Pridatech simplifies data protection through professional workflows. The tool was developed by data protection experts and is adapted to country and industry standards. We offer everything you need for a successful privacy program. It helps you to create and manage processing activities, to conduct data protection compliance analysis, to identify the gaps we spoke before about, to create and manage employees, the assets of your company, the recipients, and all the systems you work with. And of course, you can prepare a risk analysis, or more than one, of course, if you need them, based on your assets. You can conduct data protection impact assessments based on the risks of the rights of the data subject, or manage data subject requests, data breaches. So you can see here the perfect overview of all the offer, vendor contracts, but yeah, just have a look at it. And yeah, just like test it out. So you can take control of the data protection management in your company and protect yourself from GDPR penalties. We help you to detect the risks and put the right technical and organizational measures into place to protect your data. And you can contact us anytime for a free demo of our tool and try it out. You have a free trial for 7 days. And of course, you can always schedule a demo to go more into detail also, because what I mentioned was just like a very quick overview of everything Pridatech has to offer. And if a private demo can get you way more into detail with everything. And of course, for technical consultation or help with secure data storage, you can contact Alexander Sverdlov anytime directly on LinkedIn. He's there under his name, and I think he will be very happy to help you as well.
Yeah, and one more thing that I wanted to mention here. I'm not just on this webinar as an external security consultant. I've been using this platform, and I got to know this platform first as a customer. I got interested in it at a legal tech conference, and when I got interested about it, they gave me a demo. I have never seen. I mean, I'm working with DPOs globally. I have customers globally all over the globe, and many DPOs I've had discussions with. I've never seen such a usable system. It's incredible. So just try it out. You'll see for yourself.
Thank you so much. And of course, thank you for attending this webinar today. Not only you, but also the attendants. And we will now check if there are any questions. So 1 second. Do we have any questions? Like right now, here I got one. Wait, how do I, as a small company, create GDPR compliant deletion concept? GDPR compliant deletion concept. Perfect. This is very interesting. Also, as we spoke about this in a webinar before, for this you can always find different templates. And I like to work here with the DIN standard 66398 of 2016. So here I have your basic steps that tell you completely what you have to do to have a data deletion concept in the company, and they say that you should determine like the types of the data that exist in the company's databases, summarize the data types in different deletion classes, define the deletion rules for the data types, and also define a concrete implementation rules. You need, furthermore, a definition of the respective person responsible for the implementation, and you have to document the steps you take, of course. But this concept, however, is not sufficient. So you don't need only the concept when you have an audit, but of course you also need to prove that you implement such a concept of the data deletion. Any more questions for Alex? No? Okay. Wait, here is one more. So are there special rules if I'm sharing data with third parties? Yes, okay. So if you share your personal data with other organizations, you should agree on what happens once you no longer need the data you share. This most of the time happens with DPAs, so data processing agreements you have with the third party or they have with you. So if you share personal data, you should agree on that what happens. And in some cases, it may be best to return the shared data to the organization that supplied without keeping a copy, of course. And in other cases, all of the organizations involved should delete their copies of the personal data. And the organizations involved in this information sharing may each need to send their own retention periods. They need to set them because, of course, they have to keep it for a longer period of time, for example, for tax reasons. The different countries have different legislations. Here, however, if you all only hold the data for the purpose of the data sharing and no longer than needed, then all the organizations with copies of the information should delete it immediately. Yes, so you should basically do what you agreed in the DPA, delete it if no longer necessary, and then we have the several options of pseudonymization, anonymization in the case that you need to keep it for several reasons. So yes, also that happens with you if you are the third party who receives the data or if you share it with other parties. So yes, and of course, if you have more questions later on to me or to Alexander, please feel free to reach out. You have our contact details, and also we will send, of course, the presentation, the webinar later on out to all the participants. Okay. Then, thank you very much, and see you the next time.
Thank you. Thank you for participating.
Bye.